Hello friends, I'm Shantanu, your coach, and now we are going to start another chapter named Industrial Employment Standing Order Act 1946. सबसे पहले हम इसका इंट्रोडक्शन देखेंगे एक्ट का नेम, जैसा कि आपको पता है, द इंडस्ट्रियल एम्प्लॉयमेंट स्टैंडिंग ऑर्डर एक्ट 1946. दिस इज द नेम. इट एक्सटेंड्स टू होल ऑफ इंडिया इंक्लूडिंग द जम्मू कश्मीर. जम्मू कश्मीर में ये 1970 से एप्लीकेबल है ये एक्ट. देयर आर टोटल 15 सेक्शंस in it, and there is one important schedule where matters to be provided in the standing order under this act are provided. So कौन से matters होंगे standing order में, वो सारे आपको schedule 1 में दे रखे हैं. Now let's see the object of this act. The object of this act is to require employer in the industrial establishment to provide the service rules to the workmen and to formally define the conditions of employment under them. तो कोई भी वर्कर जब भी काम करता है किसी इंडस्ट्रियल एस्टेब्लिशमेंट में, उसको पता होने चाहिए व्हाट आर द रूल्स एंड रेगुलेशन फॉर वर्किंग देयर, और ये सारे रूल्स और रेगुलेशंस और जो कंडीशंस हैं एम्प्लॉयमेंट की, वो सारी उसको पता होनी चाहिए और वो प्रीमाइसेस में कहीं आपको एग्जिबिट करनी चाहिए एम्प्लॉयर को. दिस इज द मेन ऑब्जेक्ट ऑफ दिस एक्ट. नाउ लेट्स सी द एप्लीकेबिलिटी ऑफ दिस एक्ट. क्या ये सभी इंडस्ट्रीज पे लगेगा? तो यहाँ पर इन्होंने बोला है नहीं. इट अप्लाइज टू एवरी इंडस्ट्रियल एस्टेब्लिशमेंट वेयर 100 और मोर वर्कमेन आर एम्प्लॉयड और वर एम्प्लॉयड ऑन एनी डे प्रीसीडिंग 12 months. यहाँ पे याद रखना है 100. नॉर्मली आपने 10 और 20 देखा होगा, विद पावर विदाउट पावर. यहाँ पर 100 वर्कमैन की बात की है. अगर पिछले 12 महीने में 100 या उससे ज्यादा वर्कमैन एम्प्लॉयड थे तो ऐसी इंडस्ट्रियल एस्टेब्लिशमेंट पे ये एक्ट लगेगा. प्रोवाइडेड दैट एप्रोप्रिएट गवर्नमेंट में आफ्टर गिविंग 2 months नोटिस मे अप्लाई द प्रोविजन ऑफ दिस एक्ट टू इंडस्ट्रियल एस्टेब्लिशमेंट विच इज हैविंग लेस देन 100 वर्कमैन एम्प्लॉयड देयर. तो इसका मतलब है कि 100 वर्कमैन है तो बाय डिफॉल्ट ये एक्ट लग जाता है, और अगर 100 वर्कमैन से कम वर्कमैन है तो ऐसे में एप्रोप्रिएट गवर्नमेंट के पास पावर है कि ये एक्ट उस एस्टेब्लिशमेंट पे भी ये लगा सकती है बाय गिविंग 2 months ऑफ नोटिस. अब बात करते हैं कि ये एक्ट किस किस पे नहीं लगेगा, कौन कौन सी एस्टेब्लिशमेंट है, इंडस्ट्रीज है जिसको एक्सक्लूड किया है. इसके ऊपर भी क्वेश्चन आ सकता है. So nothing in this act shall apply to industry to which the provision of Chapter 7 of the Bombay Industrial Relation Act 1946 apply, or any industrial establishment to which the provision of Madhya Pradesh Industrial Employment Standing Order Act 1961 apply, provided that notwithstanding anything contained in the Madhya Pradesh Industrial Employment Standing Order Act, the provision of this act shall apply to all industrial establishment under the control of the central government. तो अगर कोई इंडस्ट्री है वो मध्य प्रदेश में है लेकिन ये इंडस्ट्री सेंट्रल गवर्नमेंट के कंट्रोल में है, तो ऐसे केस में इसके ऊपर ये एक्ट लग जाएगा. Now let's see important definitions which are provided under this act. पहली जो डेफिनेशन है दैट इज सर्टिफाइंग ऑफिसर, डिफाइन अंडर 2C. सर्टिफाइंग ऑफिसर मींस अ लेबर कमिश्नर और अ रीजनल लेबर कमिश्नर and includes any other officer appointed by the appropriate government to perform all or any of the functions of certifying officer under this act. इसके ऊपर भी क्वेश्चन पूछा जाता है, तो आपको याद रखना है सर्टिफाइंग ऑफिसर मींस लेबर कमिश्नर और अ रीजनल लेबर कमिश्नर. Now let's see the definition of the employer which is defined under section 2D. Employer means the owner of the industrial establishment to which this act for the time being applies, and includes in factory the person named under the Factories Act as a manager of the factory. तो manager of the factory को भी हम employer मानेंगे. And in any industrial establishment which is under the control of any department of any government in India, then authority appointed by such government in this behalf will be treated as employer. And when there is no authority appointed by the government, then the head of the department will be treated as the employer. In any other industrial establishment, any person responsible to the owner for supervision and control of such industrial establishment shall be treated as employer. Now let's see the definition of industrial establishment. It means an industrial establishment as defined under clause 2 of section 2 of Payment of Wages Act. इसका मतलब जो Payment of Wages Act में industrial establishment है उसको यहाँ भी industrial establishment माना गया है. दूसरा, which is a factory under the Factories Act, तो उसको भी industrial establishment माना गया है. इसके बाद third is the railway as defined under Indian Railway Act is also an industrial establishment. And the establishment of a person who for the purpose of fulfilling a contract with the owner of industrial establishment employs the workmen will also be treated as the industrial establishment. Now let's see the definition of standing order given under 2G. It means rules relating to matters which are set out in the schedule. So standing order basically means the rules which are related to the matters which are given under the schedule of this act. Now let's see the definition of standing order in detail. Standing order means rules of conduct for the workmen employed in the industrial establishment. The standing order must specify following things like classification of workmen like temporary, casual, या फिर skilled, unskilled. Second, manner of intimating the working hours, shift change, transfer, etc. to workmen. Third, it should talk about the holidays, attendance and late coming rules, leave rules, termination of employment, suspension, dismissal, etc. for misconduct, retirement age of the workmen, means of redressal of workmen against unfair treatment, any other matter as may be prescribed. Now let's see the provision relating to approval of standing order. Every employer has to prepare the standing order covering the matter which are given in the schedule of this act. 5 copies of standing order shall be sent to certifying officer, that means a labor commissioner, for its approval. The certifying officer will inform the workmen and shall hear their objection. तो workmen को अगर कोई objection है उस rule पे तो they can approach to certifying officer. After that, he will certify the standing order for industrial establishment. Until the standing orders are certified, the model standing order prepared by the government shall automatically will apply on that industrial establishment. Now further it says that the standing orders should be displayed in English as well as in local language on a special notice board at or near the entrance of the establishment. Once the standing orders are specified, they will supersede any term condition of employment contained in the employment letter. तो employment का जो contract है employer और workman का, उसको भी उसके भी ऊपर ये standing order को माना जाएगा. So if there is any contradiction between standing order and the employment contract, then standing order will prevail. Now let's see the provisions related to disciplinary action. The most important use of standing order is in case of a disciplinary action. A workman can be punished only if the act committed by him is defined as misconduct under the standing order. So, model standing order contain such acts like insubordination, that is rebel, disobedience, fraud, dishonesty, damage to employer's property, taking a bribe, habitual absence or habitual late attendance or habitual neglect of work, strike in contravention of any law, etc. are treated as misconduct under the model standing order. The certified standing order may cover other acts as misconduct as well if it is approved by the certifying officer. So whatever we have seen above, these will be treated as misconduct, but the employer may add more misconduct in this list of misconduct if it is approved by the certifying officer. Now there are important provisions related to subsistence allowance. इसके ऊपर भी क्वेश्चन आ सकता है. So where a workman is suspended by the employer pending the investigation or inquiry into the complaints or charges of misconduct against him, the workman shall be paid a subsistence allowance which will be equal to 50% of the wages for the first 90 days of suspension and 75% for the remaining period until the completion of disciplinary proceedings. Here wages has the same meaning as which is given under the Industrial Dispute Act 1947. Now let's see some important decisions which have been decided by the court. First point is that the right to get the subsistence allowance during the suspension is an unconditional right of the workman. It cannot be avoided. Second, the workmen are entitled to apply for modification of the standing order. And this application for modification can be placed by the workman anytime. Further, in one case law, it was held that where there are two categories of workmen which are working in an establishment, like daily rated and monthly rated, but the certifying orders are in respect of only daily rated workmen, then the model standing orders can be applied to monthly rated workmen. Second case, in case where there is no certified standing order which are applicable to establishment, then the prescribed model standing order shall deem to be adopted and will be applicable for such establishment. Another case law, it was held that the certified standing order are a part of the statutory and not contractual term and condition of service, and will be binding on both employer as well as on the employee or workman of the establishment.